Judiciary Committee this Thursday morning, February 27th. So we're going to start off with H105 and a version 1.2. Hopefully we'll get to, we will at some point get to H21 later this morning. May or may not get to H222 to get an update. We'll see how it all goes. So over to you, Ben.
Thank you. Nate, you mind letting me in?
I did not see you in the Zoom room. Let's make sure that.
I logged in from yesterday. That might be it.
Is he in the room at all, Nate?
The Zoom room.
No, in the room at all. I just want to make sure it's really him.
I clicked the wrong link. The one from yesterday at 9, the one today. There we go. Okay, I'll share my screen.
You're all set.
Thank you, Nate. Okay, good morning, everybody. So before the committee, or for the record, Ben Novogrodsky from the Office of Legislative Counsel. As Mr. Chair said, it's before the committee is draft 1.2 of a strike all amendment to H105. This is unedited and highlighted for convenience, so it highlights the changes from 1.1 to this one. So the first change that you will encounter is about third of the way through the bill, where you'll see on page 5, starting on line 16, the changes to the suspension duration periods. So for a first offense, a person shall serve a suspension of the person's license and privilege to operate a motor vehicle for a period of 90 days and shall be automatically reinstated after the 90-day period. For the second offense, you'll see in the next subdivision 2, it's bumped up to 145 days. You'll see also an addition of subdivision 3, and this goes to sort of outlining the procedure for suspension and reinstatement. So at the end of that suspension period, the Commissioner of Motor Vehicles shall issue a notice of reinstatement to the person serving a suspension under this subdivision upon successful completion of the suspension. That's something that, from my understanding, is relatively new in sort of this whole scheme, because really there aren't many automatic reinstatements. So since we're creating that notion here, the way someone could know that their license is now back is to receive that notice from the commissioner, rather than going through the process of reinstatement.
Automatic reinstatement after all the
Program?
Yeah, after all the programs.
No.
Penalties.
So there was discussion yesterday about that prospect. What this would do is just after you've served the suspension, your license is reinstated, but you don't have to complete YSASP in order to do that. That could, and if I got that understanding wrong, that could be changed. But my understanding is that's where the committee fell yesterday.
Yeah, I wasn't here. That's why I didn't remember that or know that. So I guess if somebody doesn't mind going back over that, if I remember right, it was in the 45-day.
It was 45 and 90, and it's been bumped up to these time periods now.
Yeah, but I'm just wondering why the program was taken out.
Well, so the program's still there. It's just your license reinstatement isn't contingent on completion of the program. So the way that this could work is that you can, because there was some discussion yesterday about how long it would take to complete YSASP. And so it decided basically that you could complete the suspension while YSASP is still pending. But if for some reason you still fail YSASP, then that's when you get into those enhanced penalties and suspensions. And there's language in the bill that says if you've already served this, it can be credited towards that enhanced suspension for failure of YSASP. So that's how it would work out.
Yeah, no, thank you. Appreciate it.
Then there was just a redesignation of what was subdivision 3 as subdivision 4, which goes to that exact point I was making, Representative Berta, that any time basically served for that suspension could be credited towards another if you fail YSAS. So scrolling further down, you'll see at the bottom of page 7, a new subsection C, which is the issuance of a notice of suspension. So in the bill already, there's an issuance of a notice of violation and requirements to register for diversion. This outlines the process for which someone receives a notice of their suspension. And this language is drawn from 23 VSA 1205. It's not identical, but let's say it was my needs. So on subdivision C, subdivision 1 of subsection C, on behalf of the Commissioner of Motor Vehicles, a law enforcement officer issuing a notice of violation in accordance with subsection B of this section shall also serve a notice of suspension of the person's operator license and privilege to operate a motor vehicle in a form prescribed by the court administrator. The form shall include the following: the effective date of the suspension's duration, an explanation of the consequences of the suspension, an explanation of the process to operate a motor vehicle with an ignition interlock restricted driver's license or certificate in accordance with 23 VSA. So that would theoretically give the person the information needed if they wanted to continue to drive during the period of their suspension. It's the interlock device process. And then finally, the projected date of reinstatement upon successful completion of the suspension. The reason why it's projected is because that's assuming that you've completed the suspension itself, and there were no issues. So that's why it's a projected date. But if something happens where you violate the conditions of no driving, then that date would theoretically change. Exactly.
What's the thinking behind the addition of the interlocking device? Why are we adding that? I'm not directed towards you, Ben, but I guess maybe the sponsor.
Well, I mean, I can.
We're thinking.
Yeah, I mean, sure. I mean, I'm
Yeah.
curious on both because it seems like a policy decision less than.
It is, I mean, it is, but really what this is that this is something that would be available to them anyway. It's a matter of just informing them on the notice that this is an option for them to pursue during the suspension of their operator's license.
But isn't the whole idea behind a suspension that they are not driving a vehicle?
But it's an interlock device, so they can drive if they blow into.
But that's my whole thing is if someone has their license suspended, why would they be given access to drive a motor vehicle for driving under the influence?
Well, that's the law. If they have that availability.
So, well, that's something else we should look at. No, seriously. I mean, like, I say that, jokingly, but I'm serious.
I just think for me, it's looking at it from two angles too, of like punishment versus public safety. And so if they're using the interlock device and confirming that they're not under the influence, it is addressing the public safety piece of it.
Yeah, I mean, I hear that, but my thing is, driving is a privilege. It's not a right. Like, it's not, there's nothing saying that people have to be able to have a license to be able to drive. And they're obviously, they've committed some kind of infraction against public safety to be in this predicament in the first place.
Is it with the interlocks, isn't there some stipulations in some of the laws where they can only use the vehicle to go to work?
I don't know off the top of my head.
Seems like we did something like that, but.
I just know that there are conditions,
Right.
And if you violate the conditions, it can add to the length of your suspension. But I can't recall if that's a specific one. Maybe.
I do remember something about using the interlock so people were still able to go to work because Vermont's so rural
Well,
and that type of thing.
I think that would be a policy consideration to justify perhaps why it's needed. Otherwise, the only other option for those people would be to find some other ride or public transportation or something like that.
And even though it's not a suspension penalty, there is, I kind of look at it, you could almost call it a fine because they are expensive. They're not. cheap.
Right, I think it's $145 installation fee. You have to get it installed by a certified installer as well. So it is a process to get it done.
Right, and monthly, regular monthly fees also.
Yeah. So, yes. So it's an option under the law now. Whether or not you want to inform someone on the notice of suspension itself is a policy decision.
So what I'm hearing is that
Why
this
don't
is,
you-
this is an option, but what?
No, it's fine. Go.
What I'm hearing is that this is an option under the law, but is it a requisite to be included in this? Like we can strike.
That's a
this.
policy
It's
decision for
policy.
you.
Okay.
Ken, then Ian.
So just backing up, Ben.
Yeah.
And this was a language that wasn't clear that we wanted to make more clear. And then on the reason why all this new language is here, it's also going to be, which I think is states, when they reapply or whatever it is, it's like it's pretty much cut and dry. That's the way it's going to be, right?
Well, so right now, the automatic suspension that goes into effect for a violation, not for a failure of the YSAS program, that initial suspension can be automatically lifted under the statute. And so that's why there's a notice that would be sent by the commissioner to the person saying, hey, your license is good again. But this is what is handed to you. What we're looking at right now is what would be contained on the notice of suspension that is handed to the person by the law enforcement officer.
Okay, and just one more thing. When you blow into those devices, if I understand it correctly, if there's any detection of alcohol on there, that car is not to start.
That's my understanding. And I do know that there has to be a certain amount of sustained pressure in order to get a correct reading as well.
I'm aware of that. So then the biggest question that's always been in my mind is Representative from Castleton brought it up is like, if there's nothing stopping an individual, they're breaking the law, obviously, but there's nothing stopping them from driving another vehicle. Right, and we know that, and that's been that way for forever. Okay, thank you.
And I just have another
But Ian.
Oh, sorry.
Yeah.
So I just want to provide, we have DMV here, so they can talk about it more, but there are hard suspensions to license where you can't get an interlock device. I don't want to exactly quote what it is because I can't remember off the top of my head, but like if you have a DUI 1, and so on your subsequent DUI, if you don't blow into an evidentiary breath test, then you get a hard suspension where you can't get an interlock device for a certain period of time. And then after that period expires, then you can get an interlock. So there is a mechanism right now where there are times when you get a DUI that's pending, like you're not adjudicated yet, where you can't get the interlock. But I think my understanding from where it is in the law, it's more like when it's more extreme. So like basically the government says if you got a DUI once, every time in the future you're gonna have to blow. And if you don't blow, you're gonna have a more extreme consequence, like a hard suspension. So I think in this instance where we're talking about a DUI, it's not even a DUI, it's a 0.02, right? Violation. In just a normal DUI 1, you can get an interlock device as an adult. And so I think getting an interlock in this circumstance is very much in line with where the DUI law is.
Yeah, Zach.
So I think another consideration too is, we're assuming that all the offenders have a vehicle of their own. And that just simply isn't a reality. If we're talking about a 12 to, 18-year-old, I mean, there are some in the state that are very fortunate that if their families have the resources to have third, fourth, fifth vehicles for multiple children in a family, that's one consideration. But if, say, the offender is driving the vehicle of a parent who needs to get to work and they have an interlock, I mean, granted, I have issues because they're not driving their own vehicle most likely. they're driving most likely a family vehicle, a shared vehicle.
So, yeah, I mean, that probably means in reality that there will be no interlock device. If the kid is using the family vehicle, it's like, you're out of luck, kid. So.
But that's my whole point. It doesn't seem applicable.
Another point of information to remember for this is, well, there are a couple. The first one is, so if we're talking about those that are under 18, they have a provisional license. So they either have a learner's permit or a junior operator's license, which can be recalled altogether. And that's been in the statute forever. So they could be stripped of that privilege altogether. We're not even talking about a suspension, and that's within the discretion of the commissioner, from what I remember. So there's that if you're under 18. And so, I think that's an important piece to remember as you're having this discussion, is that there are suspensions, but it's also within the discretion to pull the license altogether if you're under 18. If you're 18 to 21, perhaps this is more applicable, but it would be applicable to everybody as a whole. So just so the committee understands how this bill kind of works in concert with it, with other aspects.
I get that, Ben. It just doesn't seem, and again, this is not antagonistic towards you. It just isn't clear to me. And it seems like there's a lot of varied applicability. There's no universal applicability to this bill. And that's my broader concern.
Right. And the other thing too is that these are civil penalties. These are not criminal penalties. So
Right.
Typically, when you talk about proportionality, that's a consideration. When you're talking about criminal offenses, typically there may be greater sanctions that are imposed as opposed to civil penalties. So that's a sort of the philosophy behind civil versus criminal penalties. But again, policy decision.
Where's the language for the DMV just to strip?
I can't recall off the top.
But it's not included. Is it included?
Yes, it's been in the bill from the beginning.
Okay.
Yeah.
And it's fine. We can.
Yeah, I'll pull the exact reference.
As long as you say it's in here.
It is. So just to finish up this portion, so those are the data or information that needs to be included in the form. Subdivision 2 states that the suspension issued would become effective on the 11th day after the person receives notice. That's in line with the current notice of suspension under 23 VSA 1205. That 11th day is a policy decision. And then finally, a copy of the notice of suspension is sent to the Commissioner of Motor Vehicles for the records. So that's sort of the issuance process, if you will. Any other questions before I move on to the next portion? None. Again, this is more of a technical change where it goes charged with a violation. Since this is a civil penalty, it's not really a charge per se, so subject to the violation. And scrolling down further towards the bottom of the bill, these are really just technical changes on page 13, just changing the reference to subdivision A3 and subdivision B, and then in subdivision 2, just a technical change. So this subsection here deals with confidentiality and release of information. So with D, with subdivision 2, we're saying everything is confidential and exempt from public records, except as provided in the other portion of subsection H, which talks about disclosure to law enforcement or an insurance company. So again, just a technical change so that there's no confusion when interpreting the statute. And then finally, not finally, then also the addition of new subsection I, which is the reporting requirement that annually on and before November 1st, the Office of the Attorney General, in consultation with the Judiciary, the DMV, the Department of State's attorneys, shall submit a written report to the House and Senate Judiciary committees containing the following information for violations of this section occurring since the last report. So it's only looking at the past year. The number of violations, any case number, so that would be like law enforcement number or potentially diversion case number, any docket number if the case were to go to the Judicial Bureau, the outcomes of those cases or dockets, and whether the duration of suspensions issued pursuant to this section evidence a reduction in recidivism or promoted rehabilitation or deterrence, which I think kind of gets at what the committee's discussion was of, are these the right time periods to determine whether or not these people are committing new crimes, are getting the help they need, or are just are back on the straight and narrow, so to speak. And then finally, another technical correction that I added going through the statutes last night. In 1209A sub A of Title 23, there was a reference to section 1216, which, as you see in section 3, is being repealed because it's being rolled into Title 7 now. So just a little bit of a cleanup there.
So just the reporting requirement, do we need to have Willa weigh in on that, or Ian, that you work with her?
Yeah, so I spoke with Willa after the discussion on this bill yesterday, and the language here comes from that discussion. I don't know if she's seen it yet.
I don't know either. And I would have to say, just based off of my work on previous bills about data collection and trying to find trends, it may be quite difficult to uncover this information. Because especially over just like a year sample size. So that's why it's worded in a specific way about sort of if it's evidence of these things, because you can't really say, does it correlate to, because these are like kind of firm data collection terms. So to see if there's a correlation or a probability probably would require a lot longer of a time period, more data points. So that's why this is basically just saying, is there a trend one way or the other? So that's why it's phrased that way.
Exactly.
I have a question going back to page 2, and I'm in subsection A, so line 18, looking at the civil penalty of $300, and then it continues on to page 3 of $600. I'm just curious, are those typical amounts, atypical? Would a operator's license or a learner's permit be reinstated with failure to pay these amounts?
I don't think that they would, but I would defer to the deputy commissioner on that. And as far as consistency, I'd have to do a survey of other statutes to see. But I mean, these amounts have been in statute for years at this point.
Do those seem low?
That's a policy decision.
They seem low. But are you able to testify to that later? Okay, great.
Aaron and then Ian.
Just letting you know that I heard from Willa. Willa is trying to get here soon and agrees with Ledge Council on the reporting. So
Okay, so she's gonna be here this morning, and she can weigh in.
I believe so.
Okay, great. I will stop sending her the email. I was just.
No, sorry, Mark, it's harassing you.
All right, you were quicker than I was. Yeah, Ian.
Just a one word question. Page 6, line 3. On successful completion of the suspension, and this is
Come up.
we're not talking about the suspension that is connected to the programming. We are talking about the suspension that is just the automatic suspension based on the first or subsequent offense. So why the successful wording?
Why the way?
Why the successfully wording?
Well, because there are things that could happen to prevent successful completion. So for instance, if you violated the terms of your suspension.
If you,
I mean, I guess you could change it to just completion.
yeah, no, I just, so if you get like, pulled over and you were driving on a suspended license, that's a crime. So you get a new charge.
DLS, yeah.
DLS. It would somehow affect the length of your suspension.
Mhm.
Oh, okay. Cool.
Yeah, so I mean, if the committee is uncomfortable with the word successful in there and it could just be upon completion of suspension, then that's your prerogative.
Does that change the meaning of it?
I think reasonable minds could say that.
Yeah, I think it's successful myself. I mean, I think it's important to be successful at what's in front of you that you're supposed to do.
I also think it's important to be successful at things.
No, I understand that.
I'm just trying.
I'm starting to learn how your mind works, so.
So my question is just that it's clear enough what we mean by success, and it sounds like we are.
Okay.
Any other questions for Ben at this point?
I have no, and actually, this is in line 4, well, starting in line 4, subsection 4, on the same page on page 6. I'm kind of curious, just like the thinking of why an individual would receive credit for the suspension if they fail the process.
That's policy consideration that I'll leave for the committee.
Like, it seems like the clock should reset at a minimum. Like, if they shouldn't be getting credit for something that they haven't been able to complete or have been unsuccessful in doing so.
Yeah.
Well, I don't know. Are we supposed to, are we?
I don't know, are we doing committee discussion or?
Not quite yet,
Okay, never
so,
mind.
We can save it for that. I mean, but it just strikes me.
questions? Any more questions for Ben? Not seeing any. Lieutenant Revlin,
You want me to leave this up on the screen or take it down?
I'll take it down. See who else is here. So question, well, have you identified scripture?
Good morning. I appreciate the invitation. Sorry for my tardiness. The weather is not cooperating. Lieutenant Paul Ravlin, Vermont State Police, the Executive Officer of the Special Operations Unit, which also encompasses traffic safety.
So have you had a chance to look at the?
Yes, I've been, I was live streaming on the way down to the current updates. But we still are in support of the changes that are being made. And the reason for that is there's a significant piece between education and enforcement. Law enforcement has to find that balance on every interaction with individuals, whether it's a traffic stop on the side of the road, whether it's a call to a residence, whether it's an underage drinking party in the middle of a field. Like, there's an opportunity for education every time, and there's also an opportunity for enforcement every time. And what we appreciate is the committee's kind of deep dive into understanding that we have an opportunity to interact with underage offenders that might not understand the ramifications of what they're doing, but also that they have to be held accountable. There was a mention earlier about a privilege to drive is just that. It's a privilege. It's not necessarily a right. So we have to balance that. We see that a lot with adult drivers, that they to get a DUI-4 arrest is shocking to me that someone does this so many times. I mean, there's studies out there that says someone drives 80 to 100 times impaired before they're arrested one time for DUI. So if we have someone that's a repeat offender of DUI-4, DUI-5, like, that's a significant decision that they're making each time to drive impaired. So if we can get this education on early to teach them the significance of alcohol consumption or cannabis consumption, and then also choosing to drive, but also holding them accountable with the penalties. I know that there was some conversation yesterday during committee about the length of the suspension, and there were some numbers kind of going around. And personally, I think that if we mirror the current DUI suspension, it's kind of easier for everybody. And I think that there was some sort of consensus this morning that the first offense was like 90-day, which is consistent with the first offense of like a DUI, right? The second offense of a DUI or a refusal is up to like 6 months, and then you get into a year. And I know here we're talking about 145 days. So we're in support of having the education and the enforcement going hand in hand. Overall, that's kind of what our 10,000-foot view is of the changes.
Jack, thank you for making it in today. I know that the weather is tough out there. So this is actually a beautiful segue into the 145 discussion. So it seems 90, you're comfortable with that. On the upper end of the range at 145, you think that should potentially be higher.
So again, from our perspective as end users of the policy of the law, I don't want to say that doesn't really matter to us in the end of the end user.
Yeah, you hope the second offense doesn't happen.
Correct. But we also feel, again, I personally have two young drivers. My youngest son just got his license just over a month ago. So these are constant conversations that the significance of what's happening here is directly affecting my family right now as we speak, right? Because those are the conversations I'm having at my house. So the significance of the second offense and the second suspension, I look at the things that would affect like me personally, and that's what we have to take into account with these. So he needs to find a place, he needs to find a ride to his job. He needs to find a ride to his friend's house. He needs to find a ride to his baseball lessons. So these are all things that as adults, my wife and I are grateful that he can do that on his own because when he's coming home from baseball practice at 10 o'clock at night, we're glad that we didn't have to drive out there and get him, right? But also understanding that my suggestion to him, my advice to him is this is a privilege to drive. Like that can be taken from you. It's not necessarily your right to have it because you're 16. So I would say that we're remaining neutral on the conversation over a second offense and more enhanced suspensions. I don't know that from my viewpoint, we can offer the pluses or minuses. I've been trying to find studies on the recidivism of suspensions and the importance of the length of them. I haven't found anything that's been recently up to date that's convinced me to be able to speak enough about it to say this is what we want to support more or less.
Thank you. And I guess a quick follow-up from your perspective, do you think a case can be made for an increase in the 145? And it can be, I mean, I'm not trying to put you on the spot.
Yes.
I'm just trying to get the full picture.
Sure. If I take from my experience of individuals that we see that we arrest, adults, where the first suspension wasn't successful, I guess, because they made the decision again. Now, I understand it goes hand in hand with, substance abuse disorders and things that they're addicted to these things. And there's a long process other than just them driving, right? I understand there's a significance to that. But when we're talking multiple offenses of someone operating under the influence, choosing to make that decision, understanding that there is penalties and ramifications for that. And there's also programs out there to help them perhaps navigate through that, the addiction or the reasons for the consumption. I think that there's room for discussion about the length of the penalty for certainly second and subsequent offenses.
Thank you.
Other questions? So I have a couple questions. Actually following up on some of Zach's earlier questions. So as far as the interlock device, do you have any opinion on whether that should be available for the .02 individuals?
So currently under 1216, there is law stating that they're allowed to have that. Again, I think we take into account, these folks, and I know there's some conversations out there about there are some blended families. There are some families that with different backgrounds where maybe the person under 21 might be the sole breadwinner, might be the person bringing in the only income to that family or significantly helping that family with a financial background such as rent or food. And the suspension of their license, a total suspension of their license might prevent that from happening. I have sympathy for that, but I also, again, I've seen the end result of impaired driving. And I take that to heart, right? So if you're choosing to drive impaired, the end result isn't always nice. We've fatal crashes more, our a significant percentage of our fatal crashes are impaired by alcohol and drug use. And that number doesn't seem to waver if we have 70 fatals or 50 fatals, that percentage is the same. So to me, that's a significant consideration to say, if you're driving impaired, we're going to give you another opportunity to show us that you're not driving impaired by taking the interlock device. However, I have arrested folks that are purposely circumventing that by using a friend's car or a rental car.
Which wouldn't matter if they had the device or not.
Which would not matter, and that results in a criminal DLS arrest. And to be honest, I've seen both sides of that. I've had a gentleman whose car had a mechanical issue. He's borrowing a friend's car. He's trying to get to work. He requires an interlock device. He's speeding. He doesn't have an interlock device, and now he and I are spending our mornings together while he's being processed, and he's trying to get to work. And again, that's where I say, like, every interaction law enforcement has with individuals is a chance for education and enforcement. And in that case, like, sir, you know you're required to do this, and I get it. It's unfortunate that your car is, but you're required to have these. So there are some things where just it's being circumvented as well. So is it worth the discussion? I believe it is. Can I say that we have a definitive opinion saying they should or should not? I can't say that it should. I don't have enough knowledge to say that yes or no definitively.
And maybe you don't have this kind of data. Maybe this is DMV as far as how many interlock devices are being used by those under 21. Be curious to know.
So I personally don't. I do know that we have for VSP, we had about 126 violations calendar year 24 where individuals did not complete the diversion program, and they were then followed up with the ticket that we had to issue. So that's just some data showing, like, I know it's getting away from the interlock device, but it's showing that we had out of all of our tickets, we had 126 or thereabouts that failed the program and didn't follow through with it. So if they were allowed to have the RDL and then still not follow through with the program, like, we're missing that opportunity. We're allowing them to drive. We're missing the opportunity of requiring them to follow the program. So you have that with every age group, right? We have that age group adults. We have that age group with children. I don't know the percentages, but we see some of that data out there.
Right. Here.
Yes, thank you for this. And I just wanted to pick up on the DLS piece, because that's the piece that I'm trying to balance this with, of like setting out these procedures to suspend people's license, have the interlock, do this piece. And the reality is there's not 100% compliance. Folks, you're still getting DLSs.
Correct.
That are out there. And so would you agree that by having interlock, that is increasing public safety, because folks, even if it's not being used 100 by all folks, it likely is increasing public safety because folks are blowing into that potentially rather than just driving under DLS?
I would say that if we have someone that's a DUI 3 or 4 or 5, that's a significant issue in their life where they're consuming alcohol, and then choosing to make this.
And I'm focusing just on this 0.02.
Okay.
This range. Adults.
So, right. So most of I haven't had an interaction where we required a person under the age of 21 requiring an interlock device. My interactions that require folks to have interlock devices are over the age of 21. And so that would be my base of knowledge to say that I'm seeing folks, if we have someone that is their first time DUI and they are like significantly invested in making it right and doing what they need to do to get their license back, and then through the judicial system, which is based on second chances, like education and getting your stuff back and taking second chances, that these folks will take that seriously and do what they need to do and like learn their lesson, if you will. Folks that are habitually doing it, there's going to be ways that circumvent around that, and they're going to continue to figure out ways to operate. So for me to say that RDLs are making the road safer, I don't have a data point set to say, yes, these crashes were avoided because someone had an RDL. I don't know that I can put a data point to that. So I wouldn't be able to speak to say that RDLs are making the road safe. In my opinion, I don't have the data in front of me. If there may be reports out there that I haven't seen to say that. I think it's more so in a way that interlock devices are allowing folks to maintain some sort of quality of life to work and school and doctor's appointments, where they might not have had the opportunity or have to find public transportation or like a ride, something like that.
And I feel like the other thing is that there's not 100% compliance with suspensions.
Correct.
And so for me, I guess that is that piece. I would like to have the opportunity that somebody is using interlock so that I can make sure they're safer.
Correct. Having opportunities for folks to do the right thing and get the treatment that they need and continue to progress through the judicial system so that they can get back on the right path. We support that. That's the education piece. But also balancing the enforcement piece where you did make a decision to consume alcohol or cannabis, and you did choose to make to drive, right? So when we look at a DUI arrest or we look at a fatal crash, there's no one decision point that said they've made multiple decisions where if any one of those decisions were different, it's likely that that crash or arrest may not have happened, right? We certainly with like fatal crashes, like many catastrophes, there's a series of failures along the way that resulted in this type of crash. And a significant portion of that in Vermont is impaired driving. So that's why can RDLs be beneficial? I believe they can be. How effective are they? I don't have that data point for you.
So just to follow up on the 126 cases that failure to complete, do you have a number of how many people successfully completed the program?
I don't have the number off the top of my head, but I can provide that to the committee.
Thank you.
Soon after clearing here. It'll be a total number. And again, with our CAT RMS system that we use to track these, we don't have an underage party code per se.
Sure.
It might be a noise disturbance. It might be a citizen dispute. Might lead to a lot of things that end up being like an underage drinking party.
Yeah.
So, but I can get some data for you on how many total that Vermont State Police have issued, and then how many of those resulted in a failure for that.
Yeah, I would just be curious. And then something you actually just said, talking about marijuana and kind of bringing that into the conversation. So when I think of a youth substance safety awareness program, I'm thinking alcohol, narcotics, cannabis. Is that something that you think should be included in this? I mean, the focus is on alcohol, but I mean, offenders are also smoking marijuana and driving high. Is that something that we should include?
So what we're seeing for data for Vermont is drug impaired only fatal crashes outpace alcohol only fatal crashes by double.
Wow.
For the last 5+ years. I would be naive to think that folks just started smoking cannabis at the age of 21 and which led to a fatal crash. So, and some of those are underage individuals as well. We have, as probably been discussed in this committee, we have the ARIDE program, which is Advanced Roadside Impairment Detection. That's a course that's taught for officers to detect impairment other than alcohol. Then there's also the drug recognition evaluation program, which I know John Flanagan has talked about it in here as well. I spent a significant portion of my career as a drug recognition expert. So being or having the ability to detect cannabis impairment or other drug impairment is important. The issue with, I think, here with this bill is that we have a quantitative number of 0.02, which is determined by an accepted roadside PBT. With drug impairment, you have an opinion formed by a drug recognition expert that is often backed up by a blood draw, which becomes a next level of beyond a breath. Right now, we're bringing them to a hospital. We're finding a rescue agency to draw blood. Right now, we're asking a juvenile to draw blood. And then we're getting down this whole path of like a juvenile DUI where we have to bring an adult in and read them their rights. So you get some challenges there on trying to determine drug impairment and then a quantitative value, right? We can determine like, yeah, my opinion is you appear to be impaired based on my field sobriety exercises or whatnot. But the ease of having someone blow into a roadside PBT, you have your number, and it's the least intrusive steps there. So I'm not sure that this bill does or can cover that. It might have to be another, yeah.
Thank you.
So just to back up, I want to make sure, I seem to recall as far as some of the statistics on crashes and what was involved. And you said that drugs were the majority but was that polysubstance where it was alcohol and drugs? I don't recall that was a combination of both is like.
So there's a statistic that comes out every Tuesday that we get from the Agency of Transportation that talks about our fatal crashes. And historically, drug-only fatalities outpace alcohol-only fatalities, but not a combination of drug and alcohol fatalities. So there's three separate categories.
Right. And that third one is, where does that rank?
That's roughly in the middle. In the poly drug, the alcohol and drug combination is in the middle of those two
So
categories.
drugs, poly, and alcohol.
Correct.
Okay, correct. Interesting. Okay.
And cannabis is a significant, when you say alcohol and other drugs, cannabis is significantly that other drug. It's often cannabis as that second drug. When you say alcohol and drug, it's often cannabis.
That's in the poly group. In the top group, which is just drug.
Just
What
drug.
is what's the most significant drug there?
I don't have that information. That would have to be provided by the Agency of Transportation.
I think we got some of that documentation.
On what the drug is.
Session.
Early in the session?
Yeah, I was trying to find it, but
It sounds kind of familiar.
Yeah, John Flanagan would be one that be able to provide that data, or a representative from Agency of Transportation. They track that. John Flanagan is the director of the DEC program, which is Drug Enforcement and Classification Program, which all the DREs report to him. He ends up getting all that data, so he could provide it to you a lot quicker.
Yeah, I think that it's a 2023 annual report that has some of that information, I think. Karen, you have a question?
Yeah, just to clarify with the DUI drug, you can be charged with that, right?
Correct.
Yeah, so we're not negating any of that with this.
No, we're talking about the ease of like standing on the side of a field or staying on the side of a road. For the O2, it's very easily to blow in the PBT. With the drug impairment, you'd have an A-RIDE certified officer or a DRE saying yes. But again, with the O2, they're not the O8, where it'd be a criminal DLS or criminal arrest, right? With the impairment of the alcohol or with the impairment of the cannabis, if they show signs of impairment that are so significant, they would be arrested for driving under the influence of drugs.
Yeah.
So trying to find that, and I know there's been numerous conversations around what quantitative level of cannabis is acceptable to be driving, a lot like what level of alcohol is acceptable to be driving, and there's no right answer for that. And it's hard to put a number on that. So you either show signs of impairment and you're arrested, or you're showing no signs of impairment, and it would be hard for you to justify an officer to be like, okay, well, you require the diversion program because you're not showing any impairment. So it's like
possession
one
there
or
too.
possession is different.
Yeah.
Possession is different. When you possess it, you possess it.
You
So
could smell it or
Yeah.
something like that. That would give you ability to question if it's.
odor alone isn't it. But if someone's under the influence and you are trained to recognize it, there are certain physiological signs that people have, and then there's also physical signs that they have that could then lead you down the path of asking the questions of like, have you consumed? What have you consumed? Versus like, no, it was my friend that was smoking marijuana and I was next to him. So there's things that would lead you down that path, and then you could get into possession.
I just thank you for that. So like it's important for us to focus on this, that there are different paths for things. We're talking about the civil and talking about for juveniles, and there's also the criminal, and there's things that are for adults. So I think it's easy to kind of put them all together and just focusing on what's in this bill. So thank you for that.
Yes, this intertwines, this is constantly what happens in a field at 11:30 at night with
Where are we?
40 kids, right? This is what happens when we go through this. So, yes.
So I have Coach, then Ken, then Zach. Go ahead, Coach. Unmute yourself.
Good morning, everyone.
Morning.
Thank you, Trooper. I was just reviewing some National Highway Safety Traffic study information, and this goes back to a couple of the earlier questions, around, recidivism rates and uses of the interlock systems. So I just wanted to let you know, Mr. Chair, that I would send that to Nate so that we do have at least a national report in our data for at least review of the national statistics, around the use of interlocks.
No, that'd be helpful. Thanks.
Okay.
Ken?
So with the cannabis, I'm not sure it really matters whether it's if it was legalized or not, but we've actually made your job a lot more difficult to do because we really don't have necessary tools because it's like so new, even though it's been out there for a long time. So you're doing a lot of analyzing of the individual that you've stopped or pulled over or something like that. Is that correct?
So this is for driving under the influence of drugs?
Yes.
Yes. So the DRE program is a very robust program, and where you have extensively trained officers that, I mean, they carry around a bag with medical equipment in it. They have stethoscopes and thermometers and blood pressure cuffs. So they do a full evaluation on the person, and it's been around forever, since I think like 1979, started over in California. And so like most of the DREs, and I can't speak for all, and John Flanagan would probably be able to do better at that, but there's like a percentage, there's high 90s, like we're talking 97, 98% of the opinions formed by the DRE has been backed up by a blood draw that matched the category that they're of the opinion that they have formed, right? So we track that type of, so they're very good at what they do. But there is no.
This is a DRE.
This is a DRE.
Okay.
So as far as a roadside saliva test, as far as there's a roadside test that someone could blow into, like an alcohol thing or like a saliva test thing. I know there's some technology out there. I don't know the state of that technology, about where it lies as far as reliability. I know when we tested some about 10 or so, 15 years ago, it failed negative more than positive. So we had individuals that were under the arrest of driving under the influence of drugs. We offered them an opportunity to just test the machine if they wish. Some folks took the opportunity to test it, just being cooperative. Others folks didn't want anything to do with it, no problem. Nothing was recorded as far as their name or anything like that. But when they were shown positive for having drugs in their system, the machine showed negative. So we didn't invest in that technology. I don't know where it stands today, to tell you the truth. So we rely on our DREs, and we rely on our A-Ride trained officers, and our officers basically trained out of the academy can do standard field sobriety exercises and determine, like, okay, it's not alcohol, but this person is impaired. Now I need to go to the next step.
So it takes you a lot longer with a cannabis or drugs or anything like that to make an arrest or do what needs. Takes a lot more time, that and compared to alcohol, without doubt.
Well, the alcohol processing has also become pretty time heavy as far as like processing and search warrants and such. But in this case, if there's a DRE that needs to be paged, then they have to page and travel to the facility. Then there's a DRE evaluation, which takes some time. And then if the person agrees to have their blood drawn, then they're transported to a medical facility and they have to go through the triage, then into a room to get their blood drawn. So a DRE, if it could take an officer off the road for 5 to 6 hours.
How many DREs do we have?
In the state, I don't know that answer. I want to say it's mid-30s.
That
I think you have that, yeah. Yeah, I think it's
Okay, that's what I thought, only mid-30s.
I believe it's somewhere around there,
39.
39.
Good, Ken?
Just want to ask, how do we make the job easier for you to do your job?
Over the course of my career, I've been able to, I took pride in from the time I stopped the motor vehicle and determined that the person was impaired to the time I was cutting them loose with a sober driver was like 90 minutes from the roadside to having a sober driver pick them up. And then that was a processing. And then about 2 to 3 hours of paperwork following that to write my affidavit, get everything together. That significantly has increased to the point now where a single DUI arrest can be up to 7-8 hours on an officer.
And just to remind you, Ken, that's part of H44, thanks to Representative Oliver, that we have a task force trying to figure out how to streamline that.
Thank you.
Yeah.
Thank you.
Yes, sir.
So,
Yeah, go ahead, Zach. and then
thank you.
Tom.
So looking at the YSAP website and the mission statement, they are specifically talking about alcohol and marijuana. And I think this is just a broader point for follow up to the conversation that we're having, which I think is really important. And I think also a consideration for my colleagues on the committee, just to kind of think through the selective application of the mission statement for YSAP and the goals of the organization that we're trying to help, right? I think also it's worth noting, according to the Pediatric and Adolescent Medicine Journal, a study that came out is talking about those that are drinking before the age of 15 are 4 times more likely to have alcohol dependency later on in life and substance abuse issues. So I think, again, a question to you is thinking through, and I think, again, this is to you and to the committee as a whole, is do we think about broader, another provision, increasing the penalties for those below 15, and adding, I think, more accountability here. And I guess I'm just curious about your interactions with those below the age of 15, in cases like this.
Yeah, and that's a great question. And I think I would have to think that some of that mission statement would be probably derived from the youth risk assessment survey that gets taken every couple of years through the school system, where students are saying that they're taking drugs or illicit drugs or drinking or driving or taking risky behavior, doing risky behavior, and then also having an opportunity to rectify that. Now, what I have seen in my career is typically when we have young children, I mean, we're not talking 15, 16, 17, 18 years old. If we're under that age of 15, there's significant things happening in that child's life where they either feel that they have to, or they have readily access to alcohol or other drugs, where they're mimicking behavior or they're participating in that type of behavior. So I don't think that it's one stop at that age. I don't think it's a one-stop thing at that age. I think there's a significant amount of things that are occurring that there has to be some sort of intervention. Like maybe they're just their lifestyle at home is conducive to them having access to these things where they can rarely drink alcohol or rarely access cannabis or illicit drugs. So do I think there should be enhanced penalties for children younger than 15 because of the significance of it? I don't think so. I think it's more of a concern in the sense of like, what is what is a situation where they are accessing that stuff? That's kind of how I feel. And those are the examples where we've gone to houses and we've seen this, and you're looking at the child saying like, this might be a call to DCF where I got to be like, hey, this child's in need of services or something like that, right? And then typically we're not running into, as the committee has discussed previously, is like, I'm not running into a lot of 12-year-olds driving impaired. There's been some onesie twosies here where a 13-year-old stole a car and a 12-year-old stole a car. Is that significant enough for us to say we need to have this law against 12-year-olds doing this? I haven't seen enough of it to say that. So when we run into alcohol consumption of a 14-year-old or cannabis consumption of a 14-year-old, usually they're in company of an 18-year-old or they have poor living conditions at home. There's a culmination of things.
I think you bring up a really interesting point, and maybe the accountability function is less about the 15-year-old and the people supplying the stuff that's readily accessible.
There's a piece to that, right?
Yeah.
And that segues into a question that was raised last week when I was testifying about the 15-year-old driving under a permit and the person in the driver's seat is impaired or the passenger seat is impaired. The information for that is yes, the person in the passenger seat will get the civil violation, a $249 fine. No points for the responsible adult in the passenger seat being impaired when the permitted 15-year-old is driving unimpaired. Right. So there is some of that already in existence. But yes, I think that's worth being talked about as like the responsibility and providing a safe place for these kids to begin with.
Yeah. Thank you.
Earlier, when we were talking to Representative Goldstein was asking you some questions about drug recognition experts, is it worth processing a juvenile side of the road, whatever. And the ability to do that with 30 some odd DREs sounds kind of like difficult. It came to mind then, okay, well, you have possession and consumption as well as a tool. And that just made me go back and look, and I think I already answered my own question. I think between 16 and 21 years of age, we already suspend somebody's driver's license if they're caught with marijuana, not necessarily driving with marijuana. And it's a 30-day suspension, but I mean, if they were driving, you have that tool of possession and consumption.
Mm-hmm.
And I don't know if that could trigger programming well, but why do we start that at 16 to 21? No penalty below 16. Why not 12?
Mm-hmm.
I'm just wondering that was I guess, from the other things we're looking at.
I wasn't paying attention. That's your question.
That's why
I'm interacting it.
Driving, I assume.
This bill expands it to 12.
it does. Marijuana.
This is just alcohol.
I'm talking.
Well, alcohol,
Right, okay.
cannabis isn't in this bill at all.
Right, I understand, but in the cannabis law, it says 16 to 21. Throw that out there.
Separate bill.
Right, I get that, but obviously we started it at 16 instead of 12.
Right. Yeah, we should look at that. But not in this bill.
On the list.
It's arguably germane.
Well, it's in the mission statement.
Which mission statement in here?
On the website for YSAS.
Oh, yeah.
I mean, it's in their own
Yeah.
language that they are looking to combat alcohol and marijuana abuse for underage individuals. So I don't know why we're only tackling alcohol and not marijuana.
We can, do you want to respond to, well, you don't have to respond to that because that's really what we're doing. I did have another question for you, and that's the second, or so for failure, the way it's set up now is there's an automatic 90-day suspension. And then if the person fails, they have that 90 days is credited towards 180 days. Do you have any opinion on whether there should be the full 180 days if they fail, or if that first 90 days can count towards that 180 days? Do you have an opinion on that?
As an agency, I remain neutral on the length of the suspensions and the the implementation of the suspensions. I would leave that to the program managers and they might have information as to, again, where recidivism comes in and says, okay, this length of suspension is beneficial. This length of suspension for a second is beneficial. I just don't have that information. But I do go back to a comment made earlier was operation of a motor vehicle is a privilege. I mean, I have seen the end result of impaired driving, and that's all I can. That's a lot of the times that I come in. I look at fatal crash data, and again, every Tuesday we get reminded on how many lives have been taken in the state for the past 7 days, and we're at 7 already. Right? We're on record we're on track to be compared to what we were a couple of years ago. Where we had high 70s fatalities, right? And then when I go downstairs to the red ribbon ceremony in December, and we're hanging a string of red ribbons on the things that are impaired drivers, and we have so many programs, and we have so many laws, and we have so many opportunities for folks to take other forms of transportation and not drive impaired, and we're still hanging 50 to 70 ribbons, 75 ribbons on a tree of impaired drivers that have been killed or have killed somebody. And it's just, that's the huge balancing act that you have to take as far as like, how far is far enough and how far isn't far enough. And that's why I appreciate the committee's like deep dive into this, because the first read of it is like, oh, this is great. Like we're getting children the help they need early on and hopefully prevent them from being a statistic later on. And then as we're getting deeper into these different versions of this, and we're talking about lengths of suspension and how important that is, we entrust that 16-year-old. When I look out my window, my 16-year-old's driving away in a 3,000-pound car. I'm like, he's not going to text. He's not going to be driving with loud music. He's going to be paying attention. He's going to be this. He's going to be that. I'm entrusting that he has that responsibility and he takes it seriously and that he's not going to harm somebody else or himself. And I have to instill that in him, like, this is a huge privilege you have and a huge responsibility you have. With that comes the responsibility of the penalties if you don't do this like you should. Huge balancing act. And I understand, and I've been in other committees where we've talked about the significance, as I said earlier, about that person, due to the family dynamic, that person may be the one who has the delivery job, who's bringing in that extra money that family needs to be for rent or for food. And if they're suspended, what do? Do they get down the snowball effect where they drive criminally suspended and now they're going to be arrested every single time? Or do they not bring home the money for the family? But again, at the end of the day, you chose to drive impaired at that one point in your life. You made that choice, and with it comes ramifications. So significant balancing act that that the committee has to weigh. And that part of your job I don't envy, just because you have to come up with that answer. So long way around the horn, sir, but that's kind of my view on that. I think as an agency, we have to remain neutral to the experts that are employing the suspensions, but just a little background on some belief, personal belief.
Last question goes to here.
It was more clarifying, because I appreciate you pointing out the complexity of this, because there are so many different things that we're considering with this, and just really appreciate your testimony. I just wanted to put a pin in a piece that I heard, that there just really isn't any data or best practices that we can look to as far as suspension, the number of days or anything that you said that you couldn't find any.
Yes, I have a request out to a colleague in NHTSA, National Highway Safety Transportation, to provide me with some sort of recent study. I have a study of like 2005 that I'm trying to read through about lengths of suspensions and license suspensions, but I'm trying to get some more current information that's newer than 20 years old to tell us on what the thought process is around lengths of suspension and how they benefit or don't benefit. I currently don't have that data to testify on.
Okay. Yeah, but I think you're also saying that it is the complex piece of it. There's a lot of things to consider as we are thinking about the length of suspension.
There is, and I think I think the foundation starts at the privilege to have a license. That's where I think the foundation of that conversation should lie.
Okay, all right, so I appreciate that testimony very much. And so here's what we're gonna do. We're gonna take a break for about 10 minutes. I actually have a 10:30 and gonna try to track down Burdett. So if not Burdett, it'd be the esteemed Chair Kenny taking over. But I think we'll probably just get to the DMV. May have to ask Willa to come back after the floor today, because we do have some people coming in for 11 o'clock that we, and I think Willa just has to walk across the space.
And in-house appropriations at 10:45 to noon, but.
Yeah, so no, it'll probably be after the floor this afternoon, if you can make it. It should be a pretty short floor, so we're talking probably around 3:30, if that works. If that works, okay. But we will get to the DMV, so